Good morning, good afternoon, depending on where you are, and welcome to the Cannaployment webinar on best practices for confidentiality and intellectual property agreements. I am your moderator. My name is Chris Parrington. I am a partner in Zuber Lawler, practice in the firm's cannabis practice group and based out of our Minneapolis office. This is our first installment of a series of webinars that will be focused on issues and topics related to the employment law and employment issues and employing individuals within the cannabis industry. Before I introduce our unbelievably incredible panel, I must first provide a disclaimer that the views expressed by the panelists in this webinar are the personal views of the panelists and not necessarily the views of their respective companies, firms, or clients. The panelists' views should not be considered to provide any type of advice, including financial or legal advice. We also advise that cannabis is illegal under federal law, and we cannot take steps to help conceal federal law violations. Having said that, we have an unbelievably experienced, unbelievably talented panel with us today to talk about best practices for confidentiality and IP agreements. And I would love the opportunity right now to introduce them, starting with David Belsky. David is a graduate of Cornell University. He is the founder and CEO of FlowerHires, which, if you're not familiar, is an executive talent firm that has become a core building block in the cannabis industry. Under David's leadership, FlowerHires continues to actively shape the cannabis industry with more than 1,000 six-figure placements in 20 states that have legalized cannabis. David also acts as an advisor to multiple plant touching and ancillary cannabis ventures and is an investor into the cannabis business himself. Our second panelist is Greg Cowan. Greg is a business consultant with Greenleaf HR. He has many years of experience in the human resources outsourcing industry. He has earned numerous industry-wide awards and accolades, including the President's Cup in 2020 and 2021. Greg's approach to HR outsourcing is based upon a deep understanding of his clients' needs and working closely with stakeholders to create a customized solution to meet the client's organizational needs. Our third panelist is Dakeana Jones-Bishop. She's born and raised in Colorado. She's been a cannabis HR executive working in human resources and retail management for more than 25 years. She's been using her innovative and strategic HR and management knowledge in the cannabis space for more than 6 years, which started when she was the vice president of HR for LiveWell Enlightened Health. She developed the HR department and award-winning Cannabis LiveWell University during her time at LiveWell. And she was responsible for the integration and merger activity of LiveWell and PharmaCann, which resulted in her getting promoted to the position of Chief HR Officer, at which time she was responsible for overseeing more than 3,000 employees. Our final panelist is Michael Carlin, my colleague and associate at Zuber Lawler. His practice focuses on employment commercial litigation, including discrimination, retaliation, wage and hour, breach of contract, and unfair competition claims. He's experienced defending against complex class action and attorney general actions. When he's not advising companies in the cannabis industry, he typically represents Fortune 500 companies and other large multinational companies in a variety of matters involving employment law claims. And he regularly practices in state and federal courts in the state of California and the Ninth Circuit Court of Appeals. So please join me in welcoming this wonderful panel to talk about best practices for trade secrets and confidentiality and IP agreements. And having said that, we might as well jump right into this. And I'm going to direct the first question, Michael, to you, if you don't mind. I'm a litigator, trial lawyer. I've litigated a variety of different claims involving employment issues, corporate issues, shareholder issues, and a lot of times trade secret issues come up during those cases. But to be brutally honest, I find a lot of people don't really know what a trade secret is, or they think they know and they're wrong. Could you please describe for us, explain to us what exactly is a trade secret? And what are the legal elements for something to be considered a trade secret? And how does it differ from confidential information?
Yeah, of course. Thank you. And it's a pleasure to be here. So I will kind of describe the legal overview of the laws involving trade secrets. In every state, there's usually two main laws that are going to be relevant. There's the Uniform Trade Secrets Act, which is a model act that has been enacted by many jurisdictions, including California. And then there's the Defend Trade Secrets Act, which is a federal law that defines trade secrets. The definition of what a trade secret is very similar under both the Uniform Trade Secrets Act, which is state law, and the Defend Trade Secrets Act, which is federal law. It essentially provides that information that is not generally known has independent economic value due to its secrecy and has been subject to reasonable efforts to maintain its secrecy. That type of information can be classified as a trade secret, which provides some significant protections to employers to make sure that others aren't using that.
So let me follow up with that, Michael. Then it sounds to me like, trade secret laws, statutes are really state by state, even though they might be, modeled after the Uniform Trade Secret Act. But how much does the definition of a trade secret really vary state by state? I mean, how different can it really be?
So I think that it's pretty similar. 47 states and the District of Columbia have adopted the Uniform Trade Secrets Act. And you're going to see in virtually all these jurisdictions things that may be relevant to our viewers: customer lists, pricing information, internal processes and methodologies, recipes and formulas, research and development data. All that kind of stuff it can be trade secrets as long as the employer, the company, has taken the proper steps to maintain its secrecy.
Let me open this up to the entire panel. In your experience, based on your observation, is it common to include clauses in employment offers or term sheets or letters of intent that are designed to protect trade secrets and confidentiality? Or is that something that typically in your experience is really not addressed at the outset and more put into the final employment agreements?
Go ahead, Dakeana.
No, go ahead, David.
Yeah, from my vantage point, I think confidentiality is a more common thing to see in employment agreements in cannabis than even the non-competes are. And I think I do see trade secrets or, some type of mention of IP in employment agreements, especially in, director level and above candidates that are hired within cannabis. I think it's not widely adopted, but there's, considerable portion that have some form of an IP agreement as part of their sort of onboarding or offer packet.
And this is Dakeana, and thank you for having me. You definitely see those confidentiality clauses, and mostly if you're in like cultivation or MIP or R&D, any of those kind of roles, we definitely have some kind of confidentiality that is signed from the beginning so that they really understand that, just because you maybe worked on how we created something, you can't take it with you and give it to the world.
So let me follow up on that. So even when you're having discussions with a potential potential employee, or, if you're a company that's representing or working, with potential employers, you're getting confidentiality agreements and trade secret protections in place immediately, as opposed to, waiting to see if this is a real candidate or if there's a real opportunity there.
David, yeah, would be more for you.
I think it's typically upon the extension of an offer, right? You might see an NDA get signed, especially for more confidential positions or a time when a candidate needs to know sort of sensitive proprietary information about a company's finances before making a decision. But usually they're not asked to sign anything without an offer letter. I think the idea of having a candidate sign some type of IP protection without actually being an employee is, I don't really see that.
And day in and day out, like if you're just hiring for, everyday bud tenders, someone, trimmers or things like that, I wouldn't see to sign that until after they are hired as well.
Probably depends on the level that you're looking for and the extent to what's being disclosed. Obviously, C-suite levels, I'm assuming, probably will require a little more confidential information earlier on in the discussion versus, like you said, a bud tender or somebody else.
Absolutely.
Well, David, let me ask you this. Do the employment agreements that FlowerHire offers to prospective employees for its clients, do they go deeper than just a normal offer letter? And if so, can you explain, give a little detail on how and whether or not you get pushback, or whether I should say your clients get pushback on trying to go a little deeper than a traditional offer letter?
Absolutely. Well, we've been fortunate enough to support hundreds of clients at this point within the industry. And I would say every company does have its own unique onboarding process, including what type of documents they have candidates execute before joining. There are obviously some companies that just do a standard offer letter without anything else, but I think it is, and again, every company is different, but I think especially for leadership roles where they're going to be managing departments, personnel, or entire facilities, whether it's retail or production, there usually is included, I'd say at a minimum, a non sort of solicitation or confidentiality agreement, and often it will also include, if permitted by law, some form of non-compete and or IP's trade secrets clause. The thing that I get pushed back the most from the candidate perspective would definitely be the non-compete portion of that. Most candidates at that level of professional experience are accustomed to signing the other parts, the confidentiality and the IP trade secrets.
I can tell you in Minnesota, where I practice, we have, every state obviously on restrictive covenants, the laws vary. And one of the things that I know you see common here in Minnesota is the offer letter may not have the actual non-compete or non-solicit or confidentiality provision in it, but it will make note that it's contingent upon signing it. And the reason in Minnesota that's so valuable is the offer of employment can be consideration for the restrictive covenant, so long as it's offered or it's communicated to them prior to employment. If you then hire somebody and then you offer them a restrictive covenant like a non-compete, non-solicit, or some of these other confidentiality provisions, you have to give them what's known as independent consideration. Then you get into this issue of, well, is $1 enough? Is $100 enough? Is $1,000 enough? And next thing you know, you're litigating, issues that are out of control. And so, I don't know if that's something that you guys have seen and you've done, but I know in Minnesota, it's a very common practice to put in the offer letter that it's contingent upon execution of these agreements. Dakeana, let me ask you this. What role do managers and supervisors play in ensuring that employees understand and comply with confidentiality and intellectual property agreements, either ones that they sign with their employer or ones that their employers may have signed with third parties?
Absolutely. Communication is huge. First of all, you got to be able to communicate what you guys expect of your employees, and you want to do that at the time of hire, at the onboarding phase. I mean, you have to make sure that once you're giving them an NDA about social media, about any technology that the company is giving you, all of those things, you have to have the why behind it and really, have them understand exactly what they're signing. Because I've had it a million times where, someone says, well, I want to take this. I helped with this new recipe. I want to take it with me. You can't do that. But you signed this NDA, but no one explained to me what that was. So, it really is at that time, what are the expectations, and really explain those clear expectations of that NDA and what it really means. And I think that comes from your managers and HR, of course.
I'm going to ask you a question here, and I know that for employees this can be awfully scary. But if you say to them, "Hey, here's a document," when they're onboarding, let's say, or when you're bringing them on, you say, "Here's a document. You should feel free to have a lawyer look at it." The second you say get lawyers involved, they might get scared, they might get concerned. Do you do anything, or do you think managers, HR during the onboarding process, during the recruitment process? Is there any value to having some disclosure that you've given them an opportunity to have a lawyer review it, whether they actually do it or not?
I haven't ever got pushback from that in cannabis. I think people all know, some people think they're grow, masters, so they get it. They think, don't take my stuff either. So I think that, giving them that opportunity is fair. And I know I haven't had anybody get really scared about it. I just think that, it's an opportunity for them to understand where the company is coming from.
Greg, let me direct a question to you here. We talked about, I mentioned onboarding a little bit. Can you provide some details on what your onboarding process looks like at your company, especially as far as confidentiality and trade secrets are concerned?
Well, it's a little bit different. Oh, are you talking to Greg?
I was going to ask Greg. Yeah, we want to hear from Greg for a second. No, that's fine.
Absolutely.
Oh, well, thank you for the opportunity. Well, my company, Greenleaf HR, we're an HR outsourcing and technology company. And we use technology to streamline back office administration and we manage that entire employee life cycle with, through our technology platform, through the recruiting process, and especially with the onboarding process. And, you talk about documents that should be signed up, up front in the onboarding process. We have the ability to customize organizational acknowledgements, perhaps an NDA or a non-compete or some type of IP document that you'd like to have the employee signed independent of an employee handbook. So I think that you might be able to accomplish some of the disclosures, and perhaps an HR manager can provide assistance to an employee who might have specific questions about those documents in that onboarding process. And once you get through that, the employee will go through and sign an employee handbook, and then finish up the onboarding process with employee benefits or a number of other onboarding documents that we can provide as well.
In your experience, how long does that onboarding process typically take, at least, using your technology?
Well, in the cannabis industry, the bulk of employees are fairly younger. They're much more technologically astute. So, an employee can go through the onboarding process in a matter of less than 10 minutes, and in some cases as little as 5. It's our technology platform really streamlines that entire process and simplifies that process as well.
So it's very different from bringing a senior lawyer over to a law firm where you got to spend 5 days showing him how to turn him or her to turn on their computer.
Yeah, for sure. And our technology platform also, I mentioned it streamlines the onboarding process in comparison to old paper packet onboarding process, where you have to have an HR person or a representative of the company actually walk the employee through each and every document, and then you end up with a bag full of documents that typically end up in your trunk or worse. So and another great thing about our technology platform is everything that's signed through the onboarding process and elsewhere in the platform itself is digitally. There's a digital audit trail, and it all goes into the employee file, which is important, especially when there's investigations that need to be handled or conducted as well.
I know you had a comment there before I cut you off. My apologies.
Oh, no problem. No, I was going to say, the onboarding that I had, you mentioned the university that we had at LiveWell, and that was more of, the onboarding was part of that university, and that you would come in and we would give you, it was computer based, but at the same time, you were able to look through all of those documents and go through each of those. And there's someone there to explain it as well while you go along. So the process was about a couple days, even for a bud tender, just because of the regulations and compliance that is so important. So we went a little bit above and beyond, just because, back when it first came legal, we wanted to make sure that everybody understood all of those things, and then also the NDAs and all of those things that come with it.
Greg, let me follow up to this. I've heard the term electronic onboarding used. I'll be honest with you, I'm not sure I know exactly what it is, or how it differs from traditional onboarding, or the pros and cons of using it. Is electronic onboarding something I'm assuming it's something you're familiar with through your company, and can you maybe give me a little bit of understanding of what that is and how it's different from traditional?
Exactly what I described previously. The electronic onboarding process consists of an employee filling out his or her tax documents, withholding documents, then transitioning into customized organizational acknowledgements, and perhaps signing some state mandated documents for FMLA or sexual harassment, or anything else along those lines. And then, you always want to have a compliant employee handbook. And then, if your company offers employee benefits, then they'll transition directly into that employee benefit onboarding process there. And, and as I mentioned earlier, that this process is much more efficient than a traditional paper packet onboarding process. Now, there may be some specialized information that, as Dakeana mentioned in her previous role, that you'd want to have an HR professional providing assistance and direction on helping those employees understand specific documents, especially when there's legalese involved. Our onboarding process also includes a learning management system that provides trainings that you can integrate into the onboarding process for state-specific trainings, mandated trainings like sexual harassment. Like out here in California, all employers have to go through sexual harassment for their employees. So, the good thing about our system is it's customizable because, our company is not a cookie cutter type of company, and neither is yours, and neither is the company next door or down the street. So we have the ability to customize our solutions to match their needs.
If you're doing electronic onboarding, you're using technology, do you typically, do employers typically then do that prior to the start of employment? Or is that still something that's, done under the kind of like the traditional, well, it's my first day at the job, I'm going to be sitting at my desk filling out paperwork all day, not really doing anything?
Yeah, it's generally done prior to the first day. Our technology automates that entire process, and the employee will actually receive an email communication from our system asking he or she to create user login credentials and then begin the onboarding process there. And you can actually do it on your phone nowadays. That's how easy it is.
So I'm going to ask the whole panel this because Dakeana mentioned something earlier that sparked my interest, which is sometimes you have potential employees that think they're bringing something confidential. They're bringing something a trade secret to the table. My question to all of you is based on your experience. Have you had that happen where you've had either an employer that you work for or an employer that you're doing some third-party consulting work for, where they have an employee that brings confidential information and trade secrets to the table or to the new employer? And if so, how do you differentiate? How do you distinguish? How do you identify what's theirs? What's the employer's? Open to the panel. Have you experienced that, and how do you deal with that?
I can comment on that. So yeah, I've had a situation where an employee was considering whether to take an offer from a new firm, and the new firm had a very, very broad trade secrets policy that basically required any information, policies, know-how that are developed while with the employer will belong to the employer, even if the employee works on it. And that employee in particular was working on a educational program to train. This is in the real estate industry, to train new real estate agents. And what we really needed to do there is to work on the specific language of the offer letter to give that employee some protection there, because otherwise the deal wouldn't happen. It was that important to the employee that they maintain the legitimacy of that program that they're developing in their own free time, in order to eventually take that and monetize it later, and that would be completely separate from the new employer's policies. And yeah, that required the hiring entity to depart from its usual practices. But I think that at the end of the day, we were able to craft some workarounds that were able to get the deal done, and everyone was happy in the end.
David, I'm going to put you on the spot here if you don't mind, but I got to believe, given that you're dealing with, six-figure employees and placements of those types of that, management, key personnel, that you oftentimes have employees or potential employees that think that, hey, I've got some new formula for manufacturing. I've got some new, flavor formula for vape pen or for an edible, or I know how to grow the best flower. Have you come across that with any of these kind of management or key personnel candidates where they think they are contributing something, and how you communicate, work with that kind of situation of, look, that's not really something that you can protect, or this is how we protect it, or I'm just curious if you've dealt with that.
Sure. Well, I've heard those statements many times from potential candidates that they make the best drugs or grow the best flower, right? But I've never really, I don't recall ever hearing it under the guise of like, they're going to license it from me. And, I mean, they have to pay extra for these special formulas of mine. Like, they're usually excited to go work somewhere else and have the platform to, do what they do, whether it's, be a breeder of strains or be a Willy Wonka of edibles, right? They are very eager and excited about that. I mean, so, there are some examples that I remember that are like where people didn't want to do that, and those tended to be more contractor minded, I think, than full-time employee minded, that were used to sort of being hired guns and mercenaries in this emerging industry, that didn't really even understand the mindset of what full-time work actually meant. I've seen that kind of come up. There's been circumstances where, someone, maybe they are a director of cultivation, like they'll get a job and then try to, sell the company the nutrients that they have, a stake in, right, or something like that. But no, I don't ever remember that like derailing a company's ability to hire somebody. And I think, again, it speaks to this is the fringe of probably IP protection of like, well, if somebody works in manufacturing or cultivation in cannabis, like what can't they do if they go work somewhere else, right? And I think it's an interesting topic.
Well, and I think go ahead, Dakeana.
It is. And I've had where, someone has come to us and they're working, they want to come work for us, but they say, well, I have this great, I'm just fertilizer, whatever it is, fertilizer, whatever it may be, that I think that we should use. And that can't be something that we say, yes, we're going to let you do this. You can always, but that's with the communication and really the understanding that you're bringing some expertise to the company from, the position that you have, and anything you bring to the company is going to stay with that company. So I think it's just really getting some understanding, or even if they produce something while they work there that they feel like, I've had that where, I made this incredible gummy and it should be mine. No, that's not how it works. And you have to really, run through that. And I've had one case that we did go to court on, so.
Well, Dakeana, I think you're reading my mind here, because my next question was going to be exactly that. We've talked about when you have an employee bring something to the table that they think is confidential or is a trade secret that belongs to them. And I think, Dave, you're probably right. That's more of a contract situation than it is an employment situation. But I'll open it up to the entire panel. How do you ensure as an employer that what an employee is doing for you remains with you and is protected? So, inventions or improvements on existing technologies, existing products. What have you seen as ways that employers can protect and ensure that when they hire somebody to do work for them, the work product that they get out of it is theirs and doesn't belong to the employee?
So I can
go ahead.
Oh, sorry. I can kind of just touch on some things that I would recommend. So in terms of ensuring that trade secrets are protected, I think that having a strong policy, I think that a number of us have kind of discussed that, but having a written policy is really crucial to doing that. I think that it's really necessary to have a document that employees sign describing not how these trade secrets can be used and not used, most importantly, segregating duties to ensure that people who don't need to have access to those formulas, et cetera, trade secrets, don't have access to them. Additionally, one thing that employers can do is monitoring using electronic databases to see where their important trade secrets are being opened, being stored, and being transferred. That is an important step to protecting to that prong of making sure that the steps to maintain secrecy have been followed. Obviously, talking to a lawyer is going to be to get specific guidance on the specific scenario of your company is going to be also crucial.
Tina, did you have something?
Yeah, and I agree. The policy is so important that you have those in place. But more and more, what I've been hearing is that some companies aren't doing employee handbooks anymore. So there's not some, even if you have a policy, you got to make sure that they're signing off on it, because it's a lot of these policy libraries and things like that. So, once again, I think working with your legal team, make sure that NDA covers all of those bases and all of those components. And then also still having some kind of a handbook that they sign off on that has that verbiage in there, like Michael had said.
I want to move. We've talked a little bit about non-competes, and I do eventually here want to talk about that because I think that's a hot topic, not just in cannabis, but anywhere. But before we get there, Greg, I do want to ask you a follow-up question. So I've heard of something called the HRIS system. I got to be honest with you, don't know anything about it. And so I'm curious if you're familiar with it, if you can kind of explain to me, if you are, what it is, and maybe provide some examples of ways that it's improved HR processes such as recruitment, onboarding, performance management, and whatnot.
Yeah, so an HRIS is just a technical name for our technology platform. Our particular platform is called vVicient. It's a proprietary software that is owned by my parent company, Venture Employer Services. That technology platform, as I've mentioned earlier, streamlines the entire employee life cycle from recruiting with an applicant tracking service to electronic onboarding, open enrollment for employee benefits, learning management systems for training, ongoing training, employee empowerment type of activities. I think it's an essential part of any business, whether you have 5 employees or 5,000 employees. The whole idea of using technologies to create efficiencies within your organization and save time, regardless if you have an HR professional involved in the hands-on onboarding process. They're there as a support role to help new hire candidates, wade through the myriad of NDAs, non-competes, et cetera, and perhaps questions with the employee handbook and employee benefit enrollment. So they're there for. But a lot of companies have found that just using that HRIS, that electronic onboarding module, as a quick and efficient way to get your employees onboarded and to work as quickly as possible.
So I do a lot of compliance work in the cannabis space, advising employers, advising licensees on how to be compliant with, the minimal federal guidance that exists, but state and local laws, rules, and regulations. Can that system be used for compliance training and compliance purposes as well?
Sure, absolutely. I mentioned earlier that the learning management system, all those trainings can be integrated into the onboarding process itself, from sexual harassment to all the way down to OSHA trainings, for safety purposes, as a way to control costs from a risk perspective.
And I assume then if a regulator then is knocking on the door of an employer and asking for paperwork to show that you've got compliance training, or just to document the compliance of the operation, then using a system like that makes it a lot easier to get access to those records.
Yeah, absolutely. So our learning management system has approximately 300 different topics, and each time an employee engages through that training, and they'll receive a certificate of completion, and it's dropped in their employee file. one of the great features about our LMS is that it's customizable. So if an employer like Cannabis, there are basically no training modules available in any learning management system that I know of. If the employer has taken the initiative to create their own trainings, whether it's safety or leadership or any other type of training, employee development training that they want for their employees, they can upload those into our system and use that type of training. And again, all that information will be dropped in their employee file as an electronic record.
Fascinating. I very valuable. I think that, like I said, from somebody who oftentimes deals with an investigation or an inquiry by a regulator, and 99% of the time it's a bunch of paper dumped on my desk and says review it. I can tell you from a legal perspective, I think that type of technology is great, and the cannabis industry needs to make sure that compliance is a part. So I appreciate that. Thank you.
Yeah. So, one more note about that. If you have an electronic record, such as an organizational acknowledgement, there is no dispute that the employee ever reviewed that document and signed it. If you do it, if you onboard with a paper packet, then they can say, I never received it. One of those,
yeah.
Or then it comes to the question, did they review it? So I think when you onboard electronically, that eliminates a lot of the mystery there.
Dakeana, do we?
I just want to say an efficient HRIS system will save your life. I mean, that is the most important thing ever. And I will say that, it's hard in the cannabis space. Some people do not want to deal with cannabis. Right. So there's only so many HRS, companies that want to deal with it, mostly if you're attaching that to payroll. So, making sure you have the right one. I will vet someone to death before I make these decisions. It makes a world of difference. Going from paper to that, oh my gosh, you can do everything on there, and you just look someone up and you find everything. So I just wanted to chime in and say that because it is
absolutely
well said.
Well, let's move on to non-compete. So I'm going to open us up to the entire panel here. How common are you finding the use of non-compete agreements to be in the cannabis space? David, I don't know. Do you find them to be pretty common in your experience?
Yeah, I think they're the most common that I've seen within the multi-state operators. I think there's obviously they're not in none of the California operators, right? Because you can't have them in California. There are some single state operators that have had them, but I think they're definitely prevalent in the top 30 cannabis firms and less prevalent in more the SMB side of the industry.
Let me follow up on that. So as I was preparing for this webinar and educating myself, I learned that there's an FTC regulation that's been proposed that would have a significant impact on the use of non-competes, not just in cannabis, but in everything. Are you familiar with that regulation, and do you have some insight onto where you think or what impact you think that's going to have on industries where non-competes are common?
I've been following it, and I know that we're still waiting for official ruling and we're still in some comment period and all that stuff. But I think generally the biggest impact is going to be people working in the industry are going to make more money, right? Companies are going to have to do more to retain their talent in those industries. They're going to have to cash. We'll obviously talk things like retention bonuses, better equity and other types of incentives to retain folks. So people in those industries should see their earnings improve significantly. And I think you'll also see just more entrepreneurial activity, right? You'll see people that are at the point in their career where they want to go do something for themselves and build a business and take their talents and be their own boss, that will have a greater opportunity to do so and not fear, some type of legal action because of it. So I think in terms of ingenuity, innovation, compensation, those would probably be the biggest, effects if non-competes went away tomorrow.
Michael, I know you've been following the FTC proposal pretty closely. Can you give us a little bit of background into what that proposal
Yeah.
looks like, and from a legal perspective, what can businesses expect if it actually is passed and enforced?
Yeah, so the FTC issued a notice of proposed rulemaking on January 5th of this year, and the proposed rule would prohibit employers from imposing non-compete agreements on their workers, not only on their employees, but also on independent contractors. All employers would have across the US would have to remove any existing non-compete clauses from their contracts with their workers, notify their workers that the non-compete agreements are no longer effective. And the kind of narrow exception to this would be non-compete agreements between buyers and sellers, where the individual selling the business has at least a 25% stake. So it's basically taking California's law on restrictions on non-competes, banning non-competes, and applying that federally. In terms of what employers can expect that to do, well, I mean, I think that employers have these agreements to protect themselves against unfair competition by their employees. And so this just makes other types of protections that employers have, and most prominently trade secrets, confidentiality agreements, non-solicitation agreements, that makes those sorts of clauses all that more important, because employers will not be able to rely on a broad non-compete clause to prevent their employees or former employees from competing with them.
So this is just a ban on non-competes. It's not the other restrictions as it sits today.
Yeah, but the issue is that some non-solicitation clauses can be species of non-competes. So, I think that you would really need to dig into the weeds a little bit onto whether a non-solicitation agreement that you previously had would comply with these new regulations once they're implemented. I think that the comment period actually just ends tomorrow on that. And so the FTC will take some time to review the comments and promulgate the final regulation.
I'm going to open this up to the entire panel, but David, I'm going to guess you probably have some insight into this. I can tell you that, the misconception or misunderstanding about non-compete agreements is across the board. The number of times I've had people tell me that, oh, this is not, I can enforce a non-compete that says you can do anything, you can't do anything anywhere in the world forever, versus non-competes aren't enforceable at all. Or, hey, it doesn't matter what my non-compete says. I'm not going to spend the time, money, and energy enforcing it because they're not going to respond. Have you ever seen any examples where an employer has a non-compete or another restrictive covenant that they send a cease and desist letter out to a former employee or company, and the response is actually positive? It's honored. Have you guys ever seen that before?
I'm happy to go first. A few different examples come to mind, and I think taking a step back for a second, I mentioned I see it as more prevalent in sort of the larger operators, multi-state operators, and other types of businesses, and the relationship between multi-state operators and cannabis is very complex, because as much as they all like to poach talent from each other that understands the industry, they all need each other as well as wholesale partners in the states in which they operate. So it's like a delicate dance often between two companies that are competing with each other, but also need each other, right?
Yeah.
I've seen a few examples where a company sending a candidate who had resigned to go work at a competitor a cease and desist letter was enough to keep that candidate from taking the new job, right? I've seen that work out, and in every single case that I remember, that candidate ended up not going back to the former company and just working as an independent consultant until the non-compete period expired, right? Obviously you mentioned there's a difference between sending that nasty cease and desist letter crafted by a high-powered attorney and what it would take to actually litigate and enforce it. It's quite, and we explain that to our candidates and stuff, and I do agree that generally the cost of enforcement is not something that anyone, especially in cannabis right now, would really want to go through with. Another example that comes to mind was again between two MSOs, and it was a VP level candidate. And the candidate had left and started a new position. And within a month of working at the new employer, that employer got a letter saying, "Hey, this person has signed non-compete, and there could have been some trade secrets actually involved in that too. And if you want to keep him working there, we estimate the cost of what that would mean to our business would be X amount of dollars, pay us X amount of dollars, and you can still have him working there." Right. And I think that, and that they ended up firing that candidate that they had hired, that they received a letter on behalf of. But I do think, again, there was some more complexity to that relationship other than just the fear of them actually enforcing. Like, they needed this potential partner in a few states in which they both operated in.
Well, let me ask, again, kind of a follow-up to everybody. And Michael, maybe you've got some thoughts on this from a legal perspective. There's a lot of things that I think go into consideration on non-competes, not just what the non-compete says, but, the enforcement of it, how far you want to enforce it. You don't want to get into a reputational, last thing you want to be is known as a company that, has the reputation of trying to hold everybody back. You then could lose out on quality candidates. And so, I'll open it up to everybody, but Michael, maybe start with you. How can companies balance protecting their business interests with also protecting the rights of their employees, their reputation, all of these factors when talking about non-compete agreements and other restrictive covenants?
Yeah, good question. So I think that there's a couple of things. When it comes, I think that prevention is going to be the most important thing to, prevent the people who shouldn't have access to your most confidential information from getting it if they don't need to have it. And I think that there are very sophisticated systems of file monitoring out there. And I think that is probably the single most important piece of technology that you can probably put to use in order to protect those confidential and or trade secret from being disclosed. And I think having a culture of I think a positive work culture, somewhere where employees are not seeing your business as just, their 9 to 5, that, just another business that they could have, and, they could work anywhere else for, and it would be, just different people and getting money. I think having employee buy-in to the goals of the business, the mission of the business, I think that that's really important. And probably if you can get somebody to do the right thing, not steal your information, hiring right people, I think those are very important steps that employers should balance with their legal duties and these various types of agreements.
I agree. I think the IT portion of it is huge. I think you also have to have sign-offs that you have to return your laptop and all of those things, because that's where I have seen the biggest. It's like, I'm giving my 2 weeks and all of a sudden IT flags that someone is now transporting all this, everything from these files. And we're like, wait a minute, what's going on? Or someone now has brought their own, computer into the grow. Well, no, you can't do that. So I think partnering with IT, like Michael said, is huge, because that's where I've seen the biggest issue at the end of someone's employment with us.
So to the audience, we're going to be doing a Q&A session here probably in a couple of minutes. And I want to invite you, if you have any questions for the panel, you can submit them through the Q&A or through the chat option on the bottom of your Zoom screen. And I would invite you to do so. But, Dakeana, I do want to follow up with you on something. So we talked with Greg a little bit about the use of technology and systems from a compliance perspective. But I would like to ask you, what advice would you provide HR professionals who play a part in helping companies navigate regulations and ensuring compliance? What advice would you give them to either make it more efficient, more effective, just to really, fulfill their obligations when it comes to compliance?
I think that them having the knowledge of the compliance and regulations is huge. Do you actually know what that means? Don't rely on, I hate to say, on just legal or, somebody else. I think HR professionals in this space have to do a little bit more due diligence than most. I would go work in the grow. I wanted to know what was going on. I want to understand the MIP. I think if I would give any suggestion or advice, would be make sure that you have a real understanding of the industry and what that really means. Because if you're not down there with boots on the ground and understanding it, how do you know if it's right or wrong, or what's happening is right or wrong?
I will never forget and I think you're 100% correct. Early on, and when I got into the space about 10 years ago, I did a due diligence trip for a client who was looking at acquiring a company. And the first question I asked, coming from financial services and securities regulation, is who's in charge of compliance? And first I got what is compliance? Second, I got what do you mean? Third, I don't know. I think it might be my lawyer, it might be my accountant, maybe it's somebody else. And so I think you're 100% correct on that.
Thank you.
We've talked about non-competes, we've talked about confidentiality agreements, NDAs, and I'm going to open this up to the panel. Have you seen, or is there a way that you can protect in the cannabis space, specifically in the cannabis space, you could protect trade secrets and confidentiality through things like trademarks or copyrights or patents? Or is that, given the federal illegality, is that something that's off the table? Michael, I don't know if you have thoughts on that from a legal perspective or.
Yeah, so I would say that trademarks, copyrights, patents, these are forms of intellectual property protection that kind of serve different purposes from trade secret protection, but they are certainly valuable other legal protection that employers can use. Trademarks protect brand names, logos, and symbols. They don't necessarily protect the trade secret or confidential information. Copyrights protects expression of ideas, but they don't protect the underlying concepts or ideas or the trade secrets or confidential information. They can include trade secrets or, copyrighted material can include trade secrets or confidential information, but the copyright protection doesn't extend to the trade secret itself within the work. And patents are another form of intellectual property protection that provides the inventor with exclusive rights for a limited period, and it interacts with trade secrets, but many companies may decide not to patent their intellectual property, or I should say their trade secrets, because it's a limited time frame. If you look at the classic example of a trade secret, the recipe for Coca-Cola, Coca-Cola never patented that, because if they did, then they would have to compete later on. It's always been a trade secret that they've kept close.
Well, Greg, you mentioned, that there's a lot of customization and never, I'm paraphrasing a little bit, but no two employers, no two businesses are the exact same. And I think, if I'm hearing what Michael's saying, and really kind of hearing what everybody's saying, is, it's important to really understand the business, work with the right professionals, whether it's, on the recruiting side, whether it's on the HR management side, whether it's legal, whether it's accounting, whether it's technology, and really understand that no one employer is the same, no one company is the same. And some may need a non-compete, some may need a non-solicit, some may need NDAs, some may need confidentiality agreements. And more importantly, a company like yours has the ability to customize that technology to really, work with the other professionals and give each employer and each company, the ability to create what they need. Is that, am I reading that correctly, Greg?
You absolutely are. Yeah, we do a deep diagnostic with each of our respective client employers, and to understand their needs, and then create a customized service solution to align with their organizational needs. Whether you have 5 employees or 100 employees, your internal complexities are not the same. Or if you have 100 employees and the company next to you has 100 employees, there could be completely different dynamics involved in each company, and it's important for us to understand those complexities. So then we can provide that solution.
And David and Dakeana, I'm going to direct this to you. As it seems to me, tell me if I'm wrong on this, but seems to me the best way for HR professionals, HR management, employees, companies that are looking to hire to really be as effective and efficient as possible is to accept technology like Greg's talking about as a complementary add-on to what you're trying to do, not look at it as, oh, this is going to replace employees. This is going to replace the need to hire and be threatened by it. Is that, am I safe to in that assumption?
Absolutely. I mean, I think, like I said, the HRIS system saved my life. I mean, it's like if you don't embrace the technology, it's a bigger problem. The bigger you get as an organization, I started with 500 in cannabis and went to 3,000, and just having an efficient system makes it a lot easier. And you can regulate it. You can make sure everything is compliant. So you just have to embrace it.
Chris, we always tell our clients, especially the larger clients who have an existing HR infrastructure, that we're only as good as the boots on the ground. Like an HR professional like Dakeana here, our HR teams provide supplemental support to assist, professionals like Dakeana there. In the smaller groups, we absolutely can, provide that infrastructure for companies. But as a company scales, it's important to have those resources on the ground with specific skill sets.
I always tell people, and I guarantee I'm the least technologically savvy person on this panel right now. And I always tell people, don't be scared by technology, embrace it, understand it, and learn how to utilize it, even if it's the simplest things. So I definitely appreciate that. Well, as I said earlier, we're willing to take questions, provide answers if the audience members have them. I have not seen any questions come in so far. So if you have them, please submit them because we're running down to the end here. But as we're waiting for questions to come in, I'm going to open this up to the entire panel, and I'll start maybe Dakeana with you, and we'll go across the group here. But what is, if there's one thing that you think every employer should do to protect their trade secrets, to protect their confidential information, to protect their intellectual property, what's the one thing, if they don't do anything else, that you would recommend to employers based on your experience?
Absolutely. I feel like ensuring that they have those documents in place and making sure that they are upfront from the very beginning of what you're signing, the why behind it, and just ensuring that you have those documents in their file. And I think that's the most important thing that you can do.
Greg, what would you like to share on that question?
I think that employers need to lean on legal professionals like yourself to ensure that those documents that they want, whether it's an IP or a non-compete, are concisely written. And they're relevant in that state or locality to ensure the legality of that document. And then, ensure that those employees or new hire candidates have a firm understanding of what they are signing, just as Dakeana said earlier.
David, your thoughts?
I think that the solutions lie in effective HR policies and workplace culture for making sure that the hardworking people you have in your organization don't try to steal your ideas or steal the rest of your employees. It's all about how you treat people, and your best defense is a good offense in that regard, especially in the modern world, and especially in an industry that is in person, right? And you have to get really creative. But the great thing about the opportunity in cannabis is that you have that opportunity to build a company whose ethos can be unparalleled to other industries because of the values of which you see people approach this type of work in this type of industry, and their belief in the work that they do. So great opportunity to do something special, but play offense with how you treat people and how you intelligently design compensation. And you don't have to worry really as much about defense.
And Michael, contrary to the wishes of the panel and the audience, we're going to let the lawyer have the last word here. So,
Okay, I'll just be real quick.
what would you advise?
I think the most important thing is to make sure that you're actually taking steps to maintain the secrecy of your confidential trade secret information.
Wonderful. Well, thank you to everybody. Again, this has been a wonderful, wonderful topic, an unbelievably talented and knowledgeable panel, and I appreciate all of your time. Our next webinar is going to be on the topic of best practices of wage and hour compliance in the cannabis industry. Please look for that at the Zuber Lawler website. Also, for those of you that may have questions that you didn't get a chance to ask during this, you can email them to me at cparrington@zuberlawler.com, and I can forward them to the panel to get answers. And in the meantime, everyone have a wonderful day, and thank you for joining us. And to the panel, thank you so much.
Thank you.